Thank you very much. We've already formed a quorum. My voice isn't too good today, so let's start. We've already formed a quorum. First of all, the Privacy Commissioner is attending today. We've invited him. He's coming again. This is his third attendance at this meeting, so please invite the Privacy Commissioner and his team to enter the room. We've received quite a number of papers. These are correspondence between the Privacy Commissioner and the administration. I won't read out the list, so just to refer to the list of papers on the agenda. Colleagues, thank you very much. Before we formally have our summer recess, we can have an additional meeting to discuss the concerns of the Privacy Commissioner. We hope that we can handle those issues before the summer recess. When colleagues and the administration representatives are seated, I'll invite Mr. Sidney Chan, head of the e-health record of the e-health record office, to do a PowerPoint presentation. Thank you, Chairman. This is a continuation of the last discussion on the private commissioner's concerns. There are altogether 6 points of concern, and members expressed certain concerns as well. Our colleagues have prepared 6 slides. We'll go through them first and see how we should go about them. I would defer to Ms. Lee, my colleague. It's very simple. We're using these slides to roughly remind you of the concerns of the Privacy Commissioner. Let's start with the simple ones. The Privacy Commissioner did mention that in the provisions of the bill, there are 2 provisions that are of concern to him. He's worried that they are too relaxed. The first one is Clause 17(5)(g). In future, when the Commissioner is of the view that all providers of health services can be registered. Now, the Privacy Commissioner is of the view that this is too relaxed. The e-health record commissioner shouldn't be subject to such relaxed provisions. Of course, the final result may be a catch-all provision. The preceding provisions have already set out the eligibility criteria for organizations that would like to be registered. If members do not want this last resort, we agree that we can delete it. It's not that essential. The other one is Clause 20, which says that the EHRC can register certain government departments as health services providers. Immigration Department, Correctional Services Department, and the like also provide health services to their service targets. So this provision is necessary, but we can reconsider the terminology used to see whether or not we can polish the provision further. But the provision is necessary. Ms. Emily Lau, the Privacy Commissioner is here. Can we ask him to respond? Yes, maybe we should go through these slides one by one. Yes, if the Privacy Commissioner has any comments, we would like to hear him. Yes, on those 2 issues, can we have some responses from the Privacy Commissioner? Thank you, Chairman. The administration is prepared to delete the catch-all provision. That's, of course, a good proposed amendment. As for Clause 20, we heard that they had undertaken to tighten the contents of the provision. We welcome that, but by relaxation, we're of the view that the text of clause 20 seems to be more relaxed. Clause 20 now only mentions those involved in the provision of medical services. But in fact, for the applicants, they must be those who've employed healthcare personnel for the provision of healthcare. So that's quite a narrow scope. So when the administration rewrites the provision, it should follow the spirit of Clause 17.5G. Mr. Chan, will the government amend Clause 20? Mr. Chairman, we understand what the Privacy Commissioner is saying just now. Well, the word involves is used in Clause 20. Maybe this word is too relaxed. Take the Immigration Department and the Correctional Services Department as examples. They have to provide health care to their inmates, but their main services are not health care. Understand that the Privacy Commissioner would like to narrow down the scope. We agree with him, so we'll go back and discuss with our drafting division to see how we can amend it. So for these two clauses, the administration will amend them. Yes, the first provision will be deleted. The other one will be narrowed down in scope. Mr. Chairman, I can imagine that, for example, for the Correctional Services Department, for the inmates, the CSD may need to know their health conditions. Well, from the exchange of opinion just now, I could think of such a scenario. That means the CSD has to understand the health conditions of the inmates. Therefore, certain officials in charge in the CSD may not satisfy this definition of healthcare provider. So how will you handle such a situation? I cite this example because I believe operationally there's such a need to reconsider the provision. So have you ever considered the scenario that I just mentioned? Mr. Chan? Well, we share the views of Dr. Low. Clause 20 does consider that certain government departments may have to provide health care in their day-to-day services. That's why we've included the term healthcare provider here. Just now, I cited two examples, the Immigration Department and the Correctional Services Department, because they have to provide health care on a long-term basis. They might have to borrow, so to speak, a doctor from the Department of Health. And some personnel might have been trained as nurses and have been registered as nurses. So only certain personnel will be involved in the provision of healthcare in these departments. So we understand the operational needs of these departments. That's why we have this clause. In our discussion with the Privacy Commissioner, he told me that he also understood that certain departments need to provide healthcare. But he is concerned that the word involves may be too lenient, too relaxed. The terminology here is not quite the same as in the ordinance for the registration of healthcare personnel. So we'll go back and look into this terminology issue. Well, if it is not the Immigration Department or the CSD, what will happen? So we'll go back and discuss with our drafting division. Dr. Low, any follow-up? So we don't have a final decision yet. I hope that they can submit the revised version at the next meeting for our perusal. The example cited will not be excluded because of the amendment. For example, the CSD. There are other scenarios that they may think of later. If they're not considered here in future, there may be problems. Anyway, you go back to look at the content of this provision to make sure that the relevant departments will be covered. The question is, you may not be exhaustive in your deliberation. Well, Mr. Chairman, the most easy department, so to speak, is the Immigration Department and the CSD. For the Fire Services Department, which has ambulances, at present, they may not need this, but in future, they may need to provide healthcare as well. So we're not just thinking about the Immigration Department and the CSD. There may be other departments. It's okay for the FSD because it also employs healthcare personnel. Yes, qualified healthcare personnel. So a number of government departments may have to be covered, but not every government department needs to be covered. So we'll discuss with the DOJ to see how we can narrow the scope of the provision by way of a change in terminology. So at the next meeting, we'll submit the amended version to members. Members, Privacy Commissioner, any follow-up comments? Mr. Alan Leong? Mr. Chairman, concerning Clause 20, can we look at it from another angle? So long as a government department employs healthcare professionals, which are actually set out in the schedule. Instead of calling a government department a healthcare provider, you'd better allow in the provision those departments that employ healthcare professionals to, through these healthcare professionals, get registered. Would that be a better approach?
Mr. Chen, well, for Mr. Leung's comments, we can discuss that with the DOJ. Now, I can imagine that, say, in certain departments, like the Labor Department, they may have employed the 13 registered professionals as set out in the schedule. But they are not providing healthcare services as we normally understand them to be. Well, perhaps we can study this together with the DOJ. Well, please consider Mr. Leung's suggestion. Dr. Joseph Lee, Chairman, Section 20. Because I think the provision is clearly worded, and I think the Privacy Commissioner should rest assured, because in the paper it says clearly what is meant by healthcare services. Apart from the Correctional Services Department, no other government department can satisfy the requirement in that section. Well, the government is doing all sorts of things these days. Well, unless something exceptional happens, I don't see any problem with that provision. That should not be an issue of concern. Now, apart from the CSD, there is no other government department that can satisfy the requirement in that section. I think in Part 1, Clause 2, that is already clearly laid out. So please take a look. All right, Dr. Lee, thank you for your question. Any comment from the Privacy Commissioner? The key word in Section 20 or Clause 20 is involved. Now, the policy bureau may be very concerned about healthcare policies, and it may satisfy the definition of involve. Actually, a lot of government bureaus and departments are concerned about healthcare policies, and because the provision is set out in a relaxed way, then they would be able to satisfy the requirement of that section. Ms. Emily Lau. Chairman, a very large group came to seek help from me, pharmacists, doctors, and patient groups, and so on. I've written into the administration, and they are very worried about this bill. And they said that their information should not be made available casually to anyone. They should have the consent of these people before accessing the information. I think it's good that the government is planning to narrow down the clause, and I'm sure that the Privacy Commissioner is well aware of the requests of these groups, because no healthcare provider should have information or should have access to all the healthcare information. Do you think, Privacy Commissioner, do you think the amendment can satisfy the demands of the patient groups? I think Ms. Lau's suggestion has to do with later clauses and not this one. Well, Commissioner, you know what I'm talking about. So is the amendment going to satisfy the demands of the patient groups? Can you tell us? Let us know your views. Privacy Commissioner, that is very much related. The spirit of the bill is really to make information to healthcare professionals only on a need-to-know basis. So if the wordings are too lenient, then this mechanism is not going to work. So, Ms. Emily Lau, will you send us your letter? I don't think the patient groups or the professional groups will mind that, so I'll do that. Dr. Leung Ka-Lau first. With regard to the design of the bill, it poses a lot of hazards to people's privacy. I don't really know how to comment. Well, first, perhaps on the point about CSD. CSD is now providing healthcare services, but not through doctors employed by the CSD itself, but rather seconded from the DH or the HA. Well, there has been a suggestion that the CSD should employ its own doctors, but then the Director of Correctional Services said it's not feasible because there are going to be conflicts, because the inmates may like to see a doctor because he is beaten up by the CSD staff. So that may be a conflict, because if the doctor is employed by the CSD, it's likely that the doctor will say it's all right, there is not beating up. So the doctor should not be employed by the CSD. So in that case, how come you consider the CSD as a healthcare provider? The doctors should not be able to access the information. If an inmate complains that he's beaten up by the CSD staff, the doctor will have access to all his information. That doesn't work. Well, as I explained before, the CSD and the Immigration Department have a detention center in Tuen Mun. The inmates there are held there for a long time, and the doctors are seconded from the DH to provide services there. But the nurses are the employees of DH, or rather CSD and Immigration Department. They have to take an exam, and then they can provide services in CSD and Immigration Department institutions. In Siu Lam, if I remember correctly, the HA will be sending doctors at regular intervals to serve the inmates there. But of course, patients have to be sent to hospitals if they are in serious conditions. But anyway, some healthcare professionals are actually employees of the CSD and Immigration Department. So we need to have this provision to cover healthcare professionals employed by CSD and Immigration Department. So is it not the case that you are having problems with the design of your bill or the drafting of your bill? Because the Provisional Commissioner has long been advocating the proposal of giving the power to access information to individuals rather than the institutions or the providers. So that can protect privacy. Now, the drafting at present is that you will be giving the right to the entire institution and not individual professionals. So in that case, well, the director of correctional services will have access to the information as well. Now, if an inmate complains about him beaten up by the CSD colleague, that record will also be put into his medical record as well. And then the director of CS will be able to access the information as well. Now, if the drafting of the bill is such that only the doctors, the individuals will have access to the information and not the entire institution, so the inmates will get more reassured. So that's why I said that there is problem with the overall drafting of your bill and the design of your bill. Now, Dr. Lau's suggestion has to do with the proposal, the third proposal raised by Privacy Commissioner. Now, we explained before that that we do have reasons for allowing the entire institution and not the individuals to access the medical records. So on point number 3, we will do more elaboration on that. So there are actually many flaws with regard to the point of the need to know principle in the drafting of the bill. Mr. Alan Leung. For the entire part 4, from 17 to 17A to F, well, this has to do with individuals. And how come that in clause 20, then you are turning it to a government department or a government bureau? If a government bureau or department has to provide healthcare services, it has to hire healthcare professionals. Now, based on clause 17(1) and 2, one can say that I provide healthcare services at such an institution in CSD. So in that case, you don't have to have clause 20 and open up a floodgate of problems, because the government department or bureau itself will not be providing healthcare services, so to speak. So the concept really has to be related to the individuals who get registered. Well, let me supplement, Chairman. In our design, healthcare providers refer to institutions or an organization, and not individual healthcare worker under this institution. So for 17 ABCDE, 17.5 ABCDE, it lists the healthcare professionals registered under the various healthcare ordinances. Now, it's just that in 17.5F, well, if an organization doesn't belong to A to E, but then it employs these 13 professionals, it can apply to be a healthcare provider. So the unit is really an institution. And that's why in clause 20, we say that a government department can be also a healthcare provider. So I would like to thank Mr. Chan for his explanation, and he clearly states how clause 17 should be interpreted. Now, if a government bureau or department, its main work portfolio has nothing to do with healthcare provision, and it's just that in its daily work, it may have to provide minimal level of healthcare services, and in doing that, it is the service is provided by healthcare professionals. So, can we state that so that it can allay Privacy Commissioner's worries on that point? So can you consider that? Thank you, Chairman. Members, Privacy Commissioner, any supplement? So, Commissioner, I hope that you've taken on board the views. The second point is about inconsistency with the privacy ordinance. Under the privacy ordinance, if a data subject has to make a data access request, apart from making the request himself or having a guardian or parent making the data access request, he can authorize in writing another person, a third party, to make that data access request and data correction request. For our bill, in our public consultation exercise, we had concerns that if we allow for an authorization in writing for a third party to get access to a person's medical records, that may be cases of abuse, especially it will involve unscrupulous employers or agents. So because of this public concern, in our bill, we have tightened the provision, i.e., we are not allowing a data access request made on behalf of the data subject who has authorized in writing for a third party to do so. We understand the Privacy Commissioner's concern that this may be inconsistent with the privacy ordinance. So in our earlier response, we said that we will hold an open mind and we will see what members' views are before we made a final decision.
Privacy Commissioner, any response to those 2 points? Thank you, Chairman. I think the issue is very clear. In real operations, patients might find the system confusing. In future, when this bill is enacted, if it is enacted, then written authorization will not be allowed for access to his own records. But then he can invoke the privacy ordinance to obtain from the hospital authority, for example, records under written authorization. In Hong Kong, in certain scenarios, written authorization is not allowed, while in other scenarios, written authorization is allowed. I think we have to consider certain real situations. Say if a patient is bedridden, he needs assistance from other parties and individuals. He may want to change hospital or doctors. So what should he do? Is it that he must find somebody to hold him up, so to speak, to go to a healthcare provider to personally lodge an application? I don't think that's acceptable. Mr. Chan, any immediate response, or you would like to have questions from members first? Chairman would like to listen to the views of members first. We keep an open mind on this because previously some members of the public opined that they're worried about agents and employers who might also want to have access to the records. Now, the person does not have to present himself personally in front of our counters, but the application form for applying for copies of the records must be signed by him. He can ask his family members to present the completed form to us. Dr. Fernando Cheung, Mr. Chairman, we're worried that when there's a dispute about healthcare incidents, the data subject may not be able to personally handle matters. I did have the experience of handling healthcare incidents. We must obtain authorization from the data subject in order to handle his or her case, so that when we approach government departments, we can represent the subject data. The same applies to access to healthcare records. So if written authorization is not allowed, it may inconvenience the data subject. Well, I think you're repeating the issue, the concern of the Privacy Commissioner. I have another follow-up comment. Now, I'm talking about the residential homes where there may be elders, persons with disabilities, or the mentally ill. Say for an elder, if he or she does not have any family member or relative, then disallowing written authorization will result in difficulties. As for access to a patient's healthcare record, we as parents also encounter difficulties. Let me cite myself as an example. My daughter is 22 years old. She is an adult, but under the laws, she has not yet been defined as an incapacitated person. When I try to obtain information on her behalf, as I'm not a formal guardian of her, I don't have that statutory power. I have to apply to the guardianship board to become her guardian, but my application was not accepted by the board because that's ultra vires, because that's beyond the terms of reference of the board. That is, I cannot have access to her records, so I don't know how the administration is to handle such a scenario. Mr. Chan, what about the adults? How will you handle the scenario mentioned by Dr. Cheung? Well, of course, I'm not in social welfare. Now, the existing version is to prohibit a third party to obtain copies with a written authorization from the data subject. Yes, this may result in the scenario mentioned by Dr. Fernando Cheung. That is, if the data subject is an adult, there may be difficulties. Let me repeat, we keep an open mind on this. Well, even if there is a written authorization, the data subject has to sign the form. And today, if a data subject wants to apply for a copy of the record, he or she does not have to personally present himself or herself to us, but he or she has to sign the form. So Dr. Fernando Cheung, they said they kept an open mind. Maybe they are prepared to delete this provision. I don't know whether Mr. Chan is the proper person to answer this. Now, there's a loophole. My daughter is seriously mentally handicapped. She does not know how to sign. She has no cognition to authorize me to represent her. But I'm not having the capacity of a guardian. And under the existing laws, I really cannot apply to become her guardian. Well, I think this is a loophole that may affect quite many people. Do we have somebody from the Department of Justice? Yes. Maybe they can tell us whether there is such a loophole in the guardianship system. Mr. Chan, would you like to respond now? Well, why the guardianship board does not accept this sort of applications, I have to go back and look into it. Well, no matter how that ordinance reads, we have to handle Dr. Fernando Zhang's case. Well, that's a real situation. I think we have to go back to examine the issue. My colleague reminded me that today's privacy ordinance may have a similar situation. That is, if we delete this provision, we'll follow the typical practice of the privacy ordinance. But now the problem is that the guardianship board refuses to allow somebody to become a guardian. Well, this may be a loophole. Would you please go back and compare this provision and the guardianship laws and submit a written reply to us? There may be a loophole in the guardianship system. Whether or not we can handle that loophole under this bill, we'll have to put on record that we request the administration to do something under the relevant laws. So please give us a written reply so that members are clearer about the issue. Dr. Kwakaki. Thank you, Chairman. I think this is a legal issue. Clause 38 is mutually exclusive with 17A in law because they are both dealing with the personal data of patients. So, how does the administration construe this? You allow these conflicting provisions to coexist in our legal system. The other issue is if a patient is in a critical condition, he may not be able to trigger the procedures for accessing his records. Access or updating. Let me say something about access first. If a person has undergone an operation or has been admitted to the intensive care unit, usually the access request will have to be put up by his family members or other parties. So if you disallow written authorization, you may deprive the patient of proper medical treatment. That's unacceptable. As for modification of data or updating of data, this is particularly sensitive. You mentioned two parties, the employers and the insurance agents. I would like to know under what circumstances the employer or the agent may be involved. Say if the employer or the insurance agent deliberately do something, will that party be breaching the law and be subject to legal sanction? Mr. Chan? Dr. Kwok asked about a patient in a critical condition or he's in a coma. Then there's no way he can sign an application form to apply for data access. We understand that scenario. So we're willing to amend this provision. Will the patient, before he is in a critical condition or in a coma, say half a year in advance, he authorizes another party to handle his matters. Unless he does so, he will not be able to handle his personal affairs afterwards. So that's Dr. Kwok's point. Now, why don't we follow the privacy ordinance and allow written authorization? Because there were public comments that dishonest employers or dishonest insurance agents may lure the data subject into signing a written authorization. Well, maybe the employer or the insurance agents will say that we would like to create better conditions for you. Well, dishonest parties may use various reasons to lure the data subject or deceive the data subject into signing a written authorization. So back then, we would like to ban all such scenarios. But members and the Privacy Commissioner just said that if that's an absolute ban, then will not be facilitating or catering to the needs of those data subjects that really need to sign a written authorization. So maybe we shouldn't adopt an across-the-board approach. So we're ready to take away this provision and allow the data subject to allow a third party, a lawyer, a family member, an employer or an insurance agent or whatnot to sign a written or to handle his matters. Well, this is in conflict with Section 17A of the Privacy Ordinance. How will you handle that conflict? I'll defer to my colleague on how we should interpret Clause 38 in this bill. Well, any person, for example, an employer or an insurance agent, dishonestly changes the healthcare records or update the healthcare records, is legal sanction provided under the bill. And also data access as well. Well, there are two requests here, data access request and data correction request. But it's not for the applicant to make the change. Say I'm patronizing this Admiralty Hospital. I ask the Admiralty Hospital to rectify what I deem to be a mistake. So if there's no agreement here, a reason has to be given. It's not for the patient to change the record. So a third party cannot change the data. He can only put up a request for access. That is, without the data subject's consent, no changes can be made. Well, if the data subject has already authorized a third party to make a rectification request, then that third party can make a change, say from A to B.
And the ultimate decision will be made by the data user. Say a data subject may think that this piece of information is wrong, but then the data user says that, well, the information, no problem with the information, so he is allowed not to change it. Under the Privacy Ordinance, there are a list of provisions relating to data access requests and data correction requests, listing out all the conditions whereby the data user can accede or decline a data access or data correction request. So we are following the requirements of the Privacy Ordinance. It's just that in Clause 38, we are doing away with the right of the third person of the relevant person to make that kind of requests. Now, as for the penalty and so on and so forth, we'll follow the Privacy Ordinance. What about the legal framework, D of J? Well, the person responsible for drafting the legislation is not here today. I think our advice is more or less the same as Ms. Lee's. We would follow the framework of the Privacy Ordinance. If there is inconsistency, then that will be set out clearly in Part 4. Privacy Commissioner. Mr. Chan quoted two cases in your enforcement of the ordinance. Have you ever bumped into situations like those? A third party dishonestly making a data access or data correction request, is there any protection under the ordinance, the privacy ordinance, or is there a penalty under the privacy ordinance? Under the privacy ordinance, it sets out the data's subject's right to make data access request and data correction request. There is no provision on cases where there is deception. There are no such provisions. Perhaps our legal advisor can supplement a bit. Ms. Liu, on data correction request, if someone provides full information or in a dishonest manner, Section 22(4) of the Privacy Ordinance sets down a penalty. So, in other words, under existing ordinance, Mr. Chan just mentioned that there may be cases of insurance agents and employers dishonestly making a data correction request. So there is provision regulating that under the privacy ordinance. Well, does it mean that this provision will still be valid after the new bill has taken effect? I.e., if there is a third party making a data correction request dishonestly, he will be subject to the same penalty. Mr. Chan can tackle that question. Well, should we be just limiting to data access or data correction requests, or should we also cover data access requests? Yes, both of the scenarios should be covered. Well, we will be following the provisions of the privacy ordinance except stated otherwise. Now, on the present issue, we are just saying that we should not be allowing the relevant person to make data access requests. Now, Ms. Liu also explained that there is already an offense covering the scenario mentioned by Dr. Kwok. So the bill will also be implemented in the same way. Well, there are 2 to 3 members waiting to speak, and I don't have another meeting, so I will put a time limit on your speeches. Dr. Lau. Put simply, I would suggest deleting that clause altogether after having heard members' comments. Mr. Chan said that he's worried about abuses. Well, if somebody would like to abuse it, then he can still do it because you are asking the data subject to sign on it. And there is also a penalty for cases of abuse under the existing privacy ordinance. If you provide false information in making the data correction request, then one is subject to a penalty. So it seems that there obviates the need for such a requirement under this bill. All right. Ms. Emily Lau, Chairman, I tend to agree with Dr. Lau. I have a question for the Privacy Commissioner. You said that it is inconsistent with the privacy ordinance, and you heard about possible abuses. What suggestions do you have to deal with abuse cases? I think we can adopt a targeted approach towards abuse cases. Now, if somebody is resorting to deception, then we can instigate criminal investigation. Now that has to do with correction request, but what about access request? There is no element of deception. There can be no element of deception involved. So there is only a question of written authorization, whether the data subject is giving the written authorization on a voluntary basis or somebody is forcing him to give the authorization. So I think that's difficult to determine, actually. Now, somebody has signed to give his written authorization, but whether he is doing it on a voluntary basis or he's forced to do it by his employer, this is something difficult to tell. Should we be having provisions stipulating those cases? If we do have such provisions, then that will affect the relationship between the employer and the employee. Well, I would like to supplement. Well, there may be also a criminal liability related to data access requests. Can you be clearer? The lawyer, please. On data access request, if an individual makes the data access request and provides false information and misleading information in doing so, and the data subject, the data user has provided the information, and under Section 18(5), that's already an offense, attracting a certain penalty. So do you think that your provision is enough, adequate, to deter deception cases? If there is written authorization, I wonder whether that would fall into the deception cases as provided for under the ordinance. What's your view, Mr. Chen? Now, say if an unscrupulous employer or dishonest agent forces a certain individual to sign a contract, I don't think he should be caught by these two ordinances. There are bound to be other ordinances. Perhaps a crime ordinance can catch him. Because today there are many cases of unscrupulous people forcing or deceiving certain consumers into signing certain contracts. I'm sure that there are other ordinances regulating those behaviors. Ms. Lau, if we do away with that requirement, I think we can deal with the privacy ordinance, make it consistent with the privacy ordinance, but that might not be consistent with other ordinances. So I think please go back. You should go back and give us more information. You mentioned that there are other ordinances governing such scenarios. What are these other ordinances? Can we have more information so that we can rest assured that there is adequate protection? Can I supplement? Abuse cases. Now, if the abuse cases involves deception, there is certain protection under the privacy ordinance, but that is very specific because a certain deception tactic is specified. But for other abuse cases, an element of deception may not be involved, false information may not be involved, so that those cases may not fall under the these other ordinances. So I think we have to strike a balance between deterring such acts and giving the right of the data subject to make data access request. Now, under the crimes ordinance, coercion, acts of coercion may be governed. But if that tactics is not involved, then it will not be covered under the crimes ordinance. So I think we have to strike a balance overall. Now, ultimately, you have made up your mind as to whether to delete that requirement. Please give us an analysis of the situation. We have to give and take. I accept. And also, please give us an analysis on the interaction of this bill with other ordinances. I heard that most members are in favor of deleting this clause, so we can follow up duly on that, and perhaps we can take it up with the Labour Department, because I'm sure that they have dealt with a lot of cases involving unscrupulous employers. Mr. Alan Lang. Well, just one word, I support deleting this clause, because anyone should have the right to authorize another person to do something on his behalf. Now, I understand the reasons why they are coming up with this clause. Employees may be forced by their employers to give their medical records over to them. Now, but I don't think we should take away the rights of people to authorize a third party to do things on behalf just because there is a small number of unscrupulous employers. Now, I am inclined to deleting this particular clause. Mr. Chen Hanpan, you're first speaking for the first time. I would also like to ask some questions. If we are going to delete certain clauses, we have to be careful. Abuse. What do you mean by abuse? Abuse is not an absolute concept. It may be vague. So what do we mean by abuse? I have several scenarios whether these will happen. Now, somebody may go for a job interview, and the employer says that, well, I am going to hire you, but you have to go through a medical examination. And then the candidate should authorize the employer to access his medical records. Now, if a mental patient has to go to a job interview, he will be worried.
At that time, the employer may be unreasonable. He may say that as I can ask you to go for a medical examination, I can of course access your health record. So even if an employer does not have such a request now, that does not mean that he cannot put up such a request in future. You see, when you attend a job interview, you may be asked to undergo a medical examination, and insurance companies may also ask you to undergo medical examination when you want to take out insurance. If your health record is accessed by them and they put on record your health record, in future there may be disputes. Say the insurance company may say that, oh, at that time you're taking that drug. Can anybody answer this question of mine? The head of the e-health record office, Mr. Chan. Mr. Chan mentioned a number of scenarios. That is, in future, if this provision is deleted, then anybody can authorize a third party to access his health record. Mr. Chan is saying that for a job seeker, the potential employer will say that the job seeker has authorized him to access his health record. Say, for this job type, I have special requirements for taking passengers. There are certain physical or mental requirements before I can decide whether or not I recruit or employ this person. I understand that is Mr. Chan's first question. The second question is, apart from the medical examination requested by an insurance agent in the first instance, is it reasonable for the insurance agent to request every now and then to access the health record of the policyholder? I think I can discuss with the Privacy Commissioner and the Labor Department. So if a potential employer wants the job seeker to possess certain qualifications for the particular job type, can he access the person's health record? I think I have to consult the Labor Department. Well, for the hospital authority, an employer or an insurance agent may not have access to health records kept by private hospitals. But what about records kept by the hospital authority? Today, we're following closely the privacy ordinance. Even if you approach a private hospital like the Baptist Hospital, so long as you hold a written authorization from the data subject, you'll be empowered to access the health record. It may be a teacher, a friend, an insurance agent, or whatnot. From the angle of the hospital or clinic concerned, they won't care the status. They won't care about the status of that person so long as he has a written authorization. We're not sure whether those scenarios mentioned by Mr. Chan frequently occur. We don't have the data. We won't know the data if the data subject does not intend to make that authorization or is forced to make an authorization. Then today he may approach the Privacy Commissioner or the Labor Department. Privacy Commissioner, any supplement? There is a chance that the existing privacy ordinance is breached. Given that scenario, that may be an unfair collection of data. Besides, when the data subject signs a written authorization, we have to make sure that he does so willingly. That is, it is a consent agreed by the data subject. That is, whether or not he voluntarily and willingly gives that consent. Yes, the written authorization itself is clear, but whether or not it is signed voluntarily and willingly is a question. There may be a breach of law. Well, if I want to find a job, or if I want to take out an insurance policy, you may say that I willingly signed the authorization. Well, if the employee leaves the company in order to maintain good labor relations, the data subject may not come to our commission to lodge any complaint, but a complaint may be lodged later. Mr. Chan, at the moment, an access request has to be in writing. If we have this electronic platform, can things be expedited? That is, it would be very convenient, extremely convenient to provide the data. That is, immediately, almost immediately upon an authorization is given, the data can be provided electronically. Yes, you fill out a form, but the hospital authority may take months to process the application at the moment. But given this electronic platform, will data be provided very expeditiously? Does it take a month or so to provide the data? If a request is lodged with the hospital authority or any authority, under the law, the data have to be provided within 40 days, depending on the complexity of the data. Some data may be stored on paper. That may take more time. The situation varies from hospital to hospital and from clinic to clinic, but normally within 40 days. But for electronic health records, under this bill, if you want copies of 10 data, for example, as we've made all data electronic, normally we can generate a copy much quicker. To the patient, the sharing is confined to the 10 types of data specified, not the detailed health records. For the detailed health records, they have to approach the private clinic, the hospital authority, or the private hospital concerned. They keep the detailed record. So in future, if you come to our office, normally speaking, it will be quicker because all records and data are in electronic forms, but that will be confined to the 10 types of data specified. Dr. Fernando Zhang, I'd like to seek a clarification. Here, you can put up an access request or correction request. Normally, the data subject won't want to correct his health record, which is written by healthcare personnel or corrected by healthcare personnel. The patient will only want to correct his personal particulars. Well, under what circumstances will data have to be corrected? Well, if a patient patronizes a clinic or a hospital, if he dig up the records and find something very unreasonable, say he has not been taking a drug, but on the records it said that he has taken such a drug. So he would like to put up a data correction request. Yes, in case something is wrong, but the onus is on the clinic or the hospital. That is the user, the data user. Whether or not the data user agrees to make a correction. If the data user insists that the record is correct, he may refuse to correct, but then the data subject can lodge a complaint with the Privacy Commissioner. What about complaining? Well, the data subject can complain to both parties. Say in the Hong Kong sanatorium, if the Hong Kong sanatorium refuses to make a correction, the patient can lodge a complaint with the senior management of the Hong Kong sanatorium or a complaint with the Privacy Commissioner. Any room for arbitration? How to resolve the dispute? Well, as they mentioned, arbitration rests with the two commissioners, the Privacy Commissioner and the Future Commissioner. So the data subject may see who is more lenient, more kind, more generous. Well, if you reject me, I'll go to the other commissioner. Mr. Chan, perhaps my colleague can elaborate on the operational mechanisms of the two requests. We'll follow the practice of the Privacy Commissioner. Maybe the Privacy Commissioner's colleagues can elaborate. Say if a patient says that this clinic has got a wrong record and he asks for a correction, but the clinic says that it's not wrong and rejects his request. Well, this may be happening every day now. So how will the Privacy Commissioner judge whether or not the complaint should be upheld? Well, if you're talking about coordination and law enforcement as well as the handling of complaints, I believe in future the two bodies will have coordination. But law enforcement rests with us. For data access, will of course communicate with the future EHRC, because that commissioner has to ensure that the records are accurate. Maybe after we've checked, they may follow up internally. But for law enforcement, according to the privacy ordinance, any breach that leads to legal liability or statutory liability will follow the case concerned through from beginning to end. For data correction requests, as the honorable member mentioned, if there's a difference in opinion, say the doctor says that it is this disease, but the patient doesn't think so, then we should follow the provision in the privacy ordinance. That is, if the data user, that is the hospital, does not support the data correction request, then under the privacy ordinance, a slip can be included in the record to say that a person once made such a request, but they do not agree to the proposed correction. So that should be put on record. Then, of course, the hospital can reject a data correction request, because under the existing privacy ordinance, there's already such a provision. That means the healthcare personnel has the final say. Under the privacy ordinance, there are avenues through which, when there is a disagreement, a complaint can be lodged with us. Concerning these complaints, depending on the circumstances, we'll adjudicate, and then the person can further appeal to the Administrative Appeals Board. Under the privacy ordinance, yes, under the privacy ordinance.
Well, Chairman, I have actually dealt with some cases. The patient doesn't agree to the diagnosis. Say the hospital said that he suffers from anxiety and minor mental problems. He didn't agree to that diagnosis. And he could follow the avenue that you mentioned, right? What about the Administrative Appeals Board? And is it the case that you don't have any healthcare professionals in the Privacy Commissioner's office to help with the arbitration? So how can you ensure that the arbitration is good and right? Commissioner? Well, for these cases, we'll look at the diagnosis of the doctor, and doctors are entitled to their opinions. What we are asking only is that the records are kept accurate. So if there, objectively speaking, there is wrong information identified, say if a surgery is operated on the left hand, whereas the record says it's the right hand, of course, there is a mistake and the hospital must correct that data. If the hospital insists on not making the correction, then of course we would deal with the case. Now, if it has to do with medical judgment, then we would not be intervening to say that this diagnosis is right or wrong. Well, for the EHRC to be set up, would you be capable of dealing with medical information? The Privacy Commissioner's colleagues has explained how cases are dealt with under the existing ordinance. Now, maybe the record of the diagnosis is wrong, and then the clinic says that his diagnosis is right. And, well, if the data correction request is declined, then a note has to be made in the record. Now, the data subject has other avenues to take the matter forward. He can complain to the Privacy Commissioner's office and also the Administrative Appeals Board. But if the data subject is concerned about the medical diagnosis, saying, well, that goes beyond the professional scope of the Privacy Commissioner or the HRC. I think the right avenue to take the complaint to is the Medical Council, because the Medical Council has been dealing with cases of wrong diagnosis or misleading diagnosis. So that has to be dealt with the Medical Council. So such cases should go to the Medical Council. Yes, if we're talking about diagnosis of a certain case, then that has to be dealt with by the Medical Council. All right, next one, Dr. Leung Ka-Lau. Well, if we can cite concrete examples in our discussions, that would help. There may be two scenarios where a data correction request may be made. First, it has to do with insurance. Now, say if in the medical record the patient says that it was cited as the patient saying that he has been suffering from the pain for 2 years, but then the insurance policy has lasted for just 1 year only. Now, in that case, he cannot make claims under his insurance policy. So that may be one case where the patient would like to correct his personal data. The second scenario, medical opinions may differ from time to time. Now, at this juncture, the doctor may make a certain diagnosis based on past information. Now, say 3 months down the road, the patient found that the diagnosis is wrong because that was made based on the wrong information in the past. And then the patient may go to correct his previous information, and then the doctor was making a wrong diagnosis because of the wrong information supplied to him. So that may also happen. So what's important is that in your mechanism, all these requests have to be put on record. Say at this juncture, I made this medical diagnosis based on what kind of information that I have. Now, if you make a correction request later on, then my diagnosis will be based on incorrect information. Well, that has happened in the past in the hospital authority, because the doctor is held liable because he made the diagnosis based on wrong information, which has been corrected subsequently. So within the system, you must be able to trace what correction has been made to the information. Also, we have to define exactly what we mean by data. Data sometimes refer to objective facts. Data may also refer to opinions. Well, the line between the two may not be clearly drawn. Now, citing my previous example, say I have suffered from this pain for 2 years. Well, such a fact is only known to the patient. Now, if the patient insists that on record he would be saying, it is put that he is just suffering from the pain for several months. So whether that piece of information is true or not is difficult to tell, because it is only the objective fact is only known to the patient himself. It's up to really the judge to decide whether he should believe or not in this piece of objective fact. Now, we also have to be very clear about what we mean by opinions. Well, opinions should not be corrected subsequently. Say, 3 months ago, I made a certain diagnosis. It would be impossible for me to correct that opinion now. You should just be putting in a new piece of opinion, and rather than correcting the opinion made 3 months ago, that the opinion made 3 months ago could never be corrected. I can make a new opinion, give a new opinion today, but not correcting the opinion made 3 months ago. So we have to be very clear about that. So what I'm suggesting that if any correction requests are made, all the records should be kept. Would be previous versions of correction requests be still kept? Yes, I agree with Dr. Lau very much. Our design is exactly the same. We would be providing all versions, i.e. the original version and also the corrected version. We will also be able to trace the all the correction requests. What about the reasons for the correction requests? Now, yes, we would also be putting down the reasons for the correction requests as well. Now, say if I typed up the wrong word, then that would also be put down in that record. So we would be able to trace all the corrections, why the corrections were made, and all the corrections that have been made. Now, Dr. Lau mentioned about the difficulties of investigating into medical incidents. I think that goes beyond our present discussion. And I think in the computer we can have easily trace the previous versions of records. I would like to follow up on Dr. Lau's earlier question. Within the hospital authority, the same situation may arise. Dr. Leung's concern is corrections of medical records may be made too casually. What kind of criteria do we have to allow a correction to be made? Do we have any guidelines? Say, if a patient suffers from a pain for 2 years and he comes to say that I want to correct it to 6 months or several months, I mean, can you do that? Is there any guideline governing that kind of scenario? As I said, the original version of records and the amended records should be put down and side by side. As for the correction requests in the HA system, perhaps I'll defer to Dr. Zheng to tackle that. Are there any guidelines on data correction requests within the hospital authority? I think these guidelines have to be passed to the data users in the future. If the HA does have such guidelines, perhaps you should pass that to the data users in the future.
The documentation of medical records, that's already laid out in the Medical Council Code of Conduct, and I think Dr. Leung has already explained more or less that the doctors have to keep good records, and if it's an opinion that is expressed, it should be recorded, and if they have to change it, they can't change an opinion that was made in the past. If there's a mistake, they can correct it. But in the hospital authority, we have a similar mechanism, at least electronically, where all changes are logged and old versions in general are accessible. If not through the system, the front-end system, at least in the back end, it can also be retrieved. So those are, all changes are logged. Of course, in the paper world, there are guidelines on how to maintain good records, but if someone physically removes a piece of paper and destroys it, then that could be a problem. But there are guidelines on maintaining good records, which doesn't allow that.
So the answer basically is for the medical council to give all the guidelines on the proper way of dealing with medical records or medical opinions. Well, the system does have records, right? Yes. Members, any other questions? If not, then we'll go to the next page. Need to know. The third point has to do with need to know principle. The Privacy Commissioner is concerned that this principle is not clearly stated in the bill. In our earlier response, we have already explained that in terms of the legal framework, the design of the system, and also the work process, that principle is being realized, and we have explained what clauses incorporate the principle, and the Privacy Commissioner asked whether that principle should be made even clearer in the bill. Privacy Commissioner first. Chairman. The administration said that the clauses have already reflected that principle, but I hold exactly the opposite view, because I think the clauses are too general and vague. The sharing of the information is among the medical institutions. I think we need to go into more details in that. We should allow for certain individual professionals to access the information or not. Now, if we say that all staff in the same healthcare provider can access the information, of course, that is reflected in the bill, but that does not suffice. In our paper, we already said, say, in the example of a nurse doing bandages on the patient, she needs to information vastly different from that of a healthcare worker working in the A&E department. Should there be a difference in the information accessible to them? Say, in a laboratory technician, the information he needs to know may differ from that required by a specialist doctor. So is there a difference in the type of information made accessible to them? Of course, we are talking about the same patient, but the services provided by these professionals differ. So I think we should be having a clearer division on the type of information to be shared by different professionals. I think this spirit is not reflected in the clauses of this bill. This is something of great concern and worry to us. Dr. Leung Kalau? I have some other engagements in a minute, so I'll tackle this point and the next point first.
Now, you need to know that I very much agree with Mr. Chang, the Privacy Commissioner. Let me elaborate on the several aspects mentioned by the government which will not be able to support the privacy principles. Now, for the design of the legal framework, you're talking about a year of permanent authorization. Now, if the patient signs the authorization and within the validity period, somebody tries to dig out his record, and then it's discovered that suddenly somebody is digging up the records. But it is difficult to trace the issue because the patient has already authorized an access request. Now, clauses 25 and 26 says that the authorization should only be used for electronic health record only. Will be provided. Well, if I want to check Mr. Chen Hanpan's record, say if he has patronized a certain medical institution, I'd like to dig out his records to see whether or not he has contracted a certain disease. If he has contracted the disease, I'll introduce a very good drug to him. So that's for service improvement. Now, if that is not to happen, that's not my mistake, because you're only talking about future improvement. So that's clause 26. May be used for improving blah, blah, blah. Now, this is supposed to be a provision to protect privacy. It's too weak. What I mean is that it's too broad. It won't be able to make the improvement, and there's no protection for privacy. Now, what are we doing under the e-system of the hospital authority? The patient will get a PIN. If he presents his PIN to me, that means he authorizes me to do it. No signature is required. And then we hear the beep. Relevant records will be downloaded to my own computer, and the whole clinic will know those information that I would like to know. My nurses will not need to use the PIN again to access the hospital authority's record, because as a doctor I know what data are useful, and those data are downloaded. My nurses won't have the professional ability to know whether or not the data are relevant, and they don't need to access all the patient's records. For the hospital authority, we only require the PIN. The patient verbally authorizes me to check his record. I download all the particulars and data of the patient, and in accordance with those downloaded data, I treat the patient. So this so-called need-to-know provision cannot protect the privacy of the patient. And the Department of Health and the hospital authority are excluded in this sharing consent. With this sharing consent, theoretically, those institutions can readily peruse the patient's records, because statutorily, the patient has already given his consent, and those institutions are already given the exemption. That's adjoining consent. Well, Dr. Leung has to leave, but would you like to listen to the response? Oh, yes. I'll follow up on that later. Well, even after I've responded, Dr. Leung may still have his own views. The letter issue is simpler. Why is it that we've given the hospital authority and the Department of Health this joining consent? Because we would like to promote public-private initiative. We cannot force private clinics and hospitals to join, but we ourselves are public bodies. The hospital authority and the Department of Health possess the majority of patients' records. So what we're saying is that the public sector will join. Well, you are not forcing the body to join. You are forcing the patient to let people peruse his record. You're mixing this up with exemption. Well, the exemption is that the patient does not have to specify. Oh no, your remark just now was very interesting. You said you could not force private healthcare institutions to join. Well, that's another matter. But by that exemption, you're already taking away the privacy of the patient. Well, even with the Department of Health and the hospital authority, because of this joining consent, the patient will be voluntarily releasing the records. Yes, there's no opt-out option for the patient, right? Well, if a patient patronizes a private clinic or hospital, well, there are reasons for this, because one of the reasons is that the patient doesn't want the hospital authority and the Department of Health to know. That is one possibility. So with this exemption, the patient will have to disclose his record anyway. Sometimes it's because the patient doesn't want the hospital authority and the Department of Health to know. So he patronizes the private sector. Oh yes, those people who are not patronizing the public sector are more concerned. Well, previously I had some examples. The patients did not want the hospital authority and the Department of Health to know certain personal particulars. That's why they patronized the private sector. Well, Dr. Leung has to leave, but still I'd like to explain why we have this design. First of all, you want an opt-in mechanism. Now, Dr. Leung was of the view that the patient should be given an opt-out choice. A patient can choose to disclose his record only to, say, 1 or 2 private hospitals and not to the Department of Health and the hospital authority. So we have different views here, which I'd like to elaborate. The other issue is what the Privacy Commissioner said. Is this particular provision or are these provisions sufficiently protecting privacy? In 3 respects, we would like to reflect the privacy principles. Members may say that there are not that many provisions to reflect those principles. You mentioned only clauses 25, 26, and 12. And Dr. Leung was saying that these provisions were very general. What we want to say is that apart from clauses 25, 26, and 12, with different justifications, like clauses 25 and 26 mention healthcare needs, and clause 12 allows the patient to choose whom to authorize. But it's not just these 3 provisions. By way of operations, will guard against irrelevant parties to have access to the data. Say, if I'm a staff member of this hospital, say I have 3,000 staff members in this hospital, it doesn't mean that all the 3,000 staff members can have access to my data. Maybe 1,000 staff members are doing marketing, personnel management, administrative work only. The remaining personnel may be healthcare personnel. In a big system, there's a computer access system. Different staff members of different ranks and different job titles can only have access to part of the data. Say if I'm an optician, there's no reason why I should have access to all data. I have a different work area which is different from the doctors. So some data should not be accessed by the optician. That I agree. In internal workflow systems in future, we must restrict the degree to which different personnel should have access to the data. Well, this brings us back to the issue of whether or not you're talking about the system itself or the individual himself. Ms. Emily Lau, and if the Privacy Commissioner would like to supplement, please tell me. Oh, I'll let you supplement first. Just now, Mr. Chan said that future operations will take care of these aspects. Yet, as we're in the drafting stage of the bill, and we all have this worry, we're all of the opinion that the 3 provisions mentioned by Mr. Chan are not sufficient to reflect the privacy principles. Then why don't we target the drafting of the provisions now? Why don't we add provisions to the bill to ensure that we can enforce this need-to-know requirement? Well, just now the administration said that they're willing to make amendments, for the previous provisions, but they don't want to make any amendments to these 3 provisions. Ms. Emily Lau, Mr. Chairman, just now I told you that some members of the public approached me precisely in relation to these provisions. I read those provisions and did not discover any protection for the patient. Where can we find that protection? In clause 12(6), it says that the prescribed healthcare provider should follow certain format, blah, blah, blah. But what about the recipient? The healthcare recipient? Well, the Commissioner has repeated his concern. Please, Mr. Chan, tell me, which provision is there to protect the healthcare recipient in terms of data access? Mr. Chan, I think we're discussing how to give options to the patient. Say if a patient patronizes 5 clinics, how can he authorize which clinic to have data access? Well, if you refer to 12(1), the patient can choose a clinic that he has confidence in. Say amongst the 6 healthcare institutions, the patient can choose which one can have a data access. Well, should there be another provision to spell out who should make the decision? The most important point is that the patient should have the decision-making power. Well, at the end of the day, whether there is data sharing, whether there's sharing consent, that's most important. Say you can choose 3 among 5 institutions for data access. The Privacy Commissioner was saying that some people in those 3 institutions may not need to have access to the data. We'll say I choose 3 from 5, but within the 3 chosen, there may be irrelevant personnel who may also have access to my data. That's the concern of the Privacy Commissioner and Ms. Emily Lau. Through the design of the system and the operational flow, the institution concerned will know who are the healthcare personnel and which professional personnel should have more access to data. So it depends on the roles and functions of the personnel. So the operational flow, the operational system will be the safeguard, not these provisions. But of course, I understand that members and the Privacy Commissioner would like to do more in terms of the provisions.
Chairman, of course, I think it's better to write that out clearly in the bill. Is it more difficult for you to put that down in the bill than having the institutions to design their work processes to follow that principle? Now, for protecting individuals' privacy, if we just rely merely on the workflow, then the protection is not adequate. The Privacy Commissioner is suggesting that that be put categorically in the bill. What are the difficulties in doing that? Now, the bill really is to cover institutions, and the Privacy Commissioner and the members say that access of information should be made or set at the level of the individuals based on the functions of the individual professionals. Now, that may be left to the internal guidelines of the institutions. If members do think that this is still too dangerous, perhaps we can discuss that point with the DOJ colleagues and add in a clause stating clearly that only relevant healthcare professionals can have access to medical records. We'll try to add in extra clause stating that within the prescribed healthcare provider, only the relevant healthcare professionals can access the information. I think by doing that, we will be able to allay your worries, I believe. Now, Privacy Commissioner, do you think that's acceptable to you? Yes, that's a good suggestion. Okay, please go back and think about this. The groups do have strong views on this point. You have received my letter already. You don't agree. It's not that you don't agree with what I said, but then, well, depending merely on the work process, it isn't sufficient. So please write that down into the bill. Dr. Kwakaki, Chairman, about the need to know principle. I think there is a need to state clearly the occupations that have access to information. HA has some 40,000 employees, and only several professions need to know the medical records: doctors, nurses, and allied health professionals. Supporting staff don't need to access information. And more importantly, the hospital is an open environment, an open system. There have been cases where patients' privacy rights have been infringed upon. And there is a code setter now, and this is put on the tables of the healthcare professionals. They would not put it in their pocket all the time. They would just leave it on the table or their desk. And if there are ill-intentioned people, they would just take the code setter, get the code, and get into the system. And that's very dangerous. Now, in the privacy ordinance, you said that illegal use or misuse of information there carries a penalty. But then if you state clearly the kind of professionals who can have access to information, then that will encourage patients to get enrolled in the system, because they know that their information is well protected. So, well, please do that. Section or clause 12, need to know basis principle. I don't agree that the DH and HA should be made default health care providers for getting access to information. Now, your present thinking is that it will be a one-way type of information flow. The DH and the HA should need to use the information most, but that might not be the case in the future, because once the bill is enacted, there may be exchanges of information among private institutions as well. So let me cite an example. I'm a patient. I may visit this medical institution, and 5 people in that medical institution may access my information. If I go to another medical institution, another 5 people. But then if I visit or consult HA, now we're talking about thousands of people getting access to my information. Now, if we're just talking about nurses, doctors, and allied health, that we're still having a quantity of 10,000 to 20,000 people having access to my information. Now, maybe a patient would like just Admiralty Hospital to know my information, but once I give that sharing consent to Admiralty Hospital, then HA and DH can have access to all my information. So that's not reasonable. Well, if we do it that way, it will attract criticisms, definitely. Is it the case that the government wants to have monitoring of all medical records of all people? Is this the intent behind this provision? And that is feasible, that's workable. Are you going to politically persecute me now that you have my information? I agree with the Privacy Commissioner's view. I think the safe deposit box concept is very important. If that concept or proposal is feasible, why aren't you giving the right of the information provider to have control on who can access what type of information he has? Now, you can do it in an administrative way, and a patient, say, can be given an opt-out option, allow him to opt out from having his information accessed by the hospital authority. Mr. Chen, any response? I'd like to explain that in the design of this bill, in the public consultation paper and also the consultation sessions, we said that first of all the patient can choose whether to join the scheme or not. And once he chooses to join the program, he is giving the sharing consent voluntarily to the HA and DH. At that time, there is no objection raised to this proposal. So we are designing our system in that direction. Now 5 years have lapsed, and the technical work of the system has been completed. Now today, 2 members find that arrangement problematic. Well, say a patient doesn't trust the DH or the HA. Is there a way that I can opt out? Now, if we go down that route, it has to do not only with the bill, but we have to change the system altogether. Now, the 2 members, they are working in the sector, and they raised this proposal. So I have to study with my colleagues on the implications of this suggestion. I have to do more analysis before I can get back to you with a response next time. I welcome technical assessment of that point. I think this point is very critical. If you just do it your way, more patients would choose not to join the scheme. In the future, many more patients may not be using the service in the public medical or healthcare system. Well, Dr. Zhang, you should know that the HA has access to information of all patients. So if the system works just purely within the public healthcare system, then the system works smoothly and will not pose any delays or hurdles to patients getting treatment. Now, what we're talking about today is that the patient has the right to choose which to give his sharing consent to what healthcare provider. And now, within the DH and HA system, the patients within those systems have no choice to opt out because they are already within the system. And this is very different from the sharing system we are talking about. What we are talking about today is sharing among many different institutions and also between private and public healthcare providers. And the patient must have his or her own right to make a decision on whether to, in what way his consent to share information should be given. Well, we still have only 5 minutes left, and Dr. Fernando Zhang has indicated his wish to speak. I don't think we can go through all the 6 points. Perhaps we will leave the others to the next meeting. I will not extend the meeting. Dr. Zhang, I'm going to repeat some points here. I think we should specify the healthcare professionals which have access to information, and also I support taking away the default arrangement for HA and DH, I think the patient should have the right to choose. Thank you, Dr. Zhang. When we will have the next meeting, end of September, early October, we will try to schedule a time. Anyway, we have still 3 more points to cover. And when we come back in late September and early October, the administration can also supplement, provide further information on the first 3 points. I mentioned the point about guardianship rights for mentally incapacitated persons. Yes, please give us information on that point as well. Chairman, on the several points raised, if the government or the administration is willing to accede to our requests, why don't they give us some revised draft of the clauses so that we can expedite our work? Please present the revised draft clauses, and then we can get things done more quickly. Yes, please do so. So the next meeting will be held in late September and early October. Some papers have been tabled, including the letter written by Ms. Elizabeth Quat and also the administration's response. I think that has to do with the safety boxes, so we'll leave that to the next meeting as well. Privacy Commissioner, you've been here for 3 times. I can't remember exactly 3 or 4 times, but perhaps we would like to invite you to the next meeting as well. Thank you, Privacy Commissioner. Meeting adjourned. Thank you.